As my supervising partner, I am hoping that you will find that I am competent to go ahead and interview and advise Mr. Barnes as to the best types of business organizations which will be suitable to his business goals and personal circumstances. If you will allow, I will question Mr. Barnes to determine his level of financial and participation support which will be required to establish and carry out his prospective business. I will ask questions which relate to the skills, time, and funds he will require in relation to the skills, time, and funds that he has available. If Mr. Barnes would like to be in full control of the commercial operations, I will explore the possibility of a sole trader. This will afford him maximum regulatory flexibility without limiting the potential for growth. However, this law will provide no protection for Mr. Barnes as a business owner. I will advise him against this type of business if the financial risk attached to the establishment and the carrying on of the business is high in relation to his financial capacity. The time and skills required in relation to that which he has available will also be relevant. A sole trader organization will not be ideal unless the business is low risk considered in conjunction with his capacity. He will owe unlimited and full liability for any debt incurred by the business, as the business and Mr. Barnes himself will be a single legal entity. I assure you, my client will not be entering bankruptcy due to my failure to provide sufficient duty of care in addressing this absolutely crucial matter. If it would suit Mr. Barnes more appropriately not to be solely responsible for the business, which may be due to personal commitments or lack of required skills or capital, I will discuss the possibility of a partnership, which will be governed by the Partnerships Act 1981 of Queensland. According to Section 5, subsection 1 of the Act, a firm will be established if Mr. Barnes enterprises with at least one other stakeholder who intends to create a profit, and this will be regardless of whether they intended to form a firm, at Section 6. The High Court case of Lang and James Morrison is an example of the importance of maintaining behaviour which is distinctive of a partnership should the partners wish to be a partnership at law. Now, while this is a Victorian dispute, the Partnerships Act in Victoria is deceptively similar to our own here in Queensland, and the principles surrounding this matter are the same. According to sections 8, 13, and 15, all partners of a firm will be jointly and severally liable for any business carried out by a partner in the ordinary course of the business, including those activities which were unauthorized or wrongful. For example, in the classic 1962 case of Mercantile Credit and Garage, the court held that the partnership was responsible for the contract of the sale of the car, despite the fact that sales of cars were absolutely forbidden in accordance with the partnership contract. This is because it was deemed to be within the scope of the business activities. It will be important to discuss further characterizing principles of partnerships with Mr. Barnes, such as those contained in Section 27. This lists that all partners will have equal responsibility for the assets and liabilities of the business, that all partners will be entitled to participate in the management of the business, that changes must be agreed on by the majority of all partners, and that no new partner may be included into the firm without the consent of all existing partners. As these provisions are subject to agreement, Mr. Barnes may choose to employ the skills and experience of such co-partners to assist him in managing the business. Alternatively, he may opt to take more control by agreement. He will also find that the Act offers protection through the provision of express and implied fiduciary obligations, such as those regarding competition in Section 33. Mr. Barnes may choose to establish a limited partnership pursuant to Section 27 upon the consent of all partners following the instructions in Section 50. This allows for some members to be limited partners as per the agreed terms in the registration forms, while the remaining partners will be general partners who owe unlimited liability pursuant to Sections 49 and 53 of the Queensland Partnerships Act. This could be advantageous for Mr. Barnes if he requires the skills of a particular partner who is unable to contribute the funds which might be required by a general partner. This could be advantageous for Mr. Barnes if he requires the skills of a particular partner who perhaps is unable to contribute the funds that a general partner would be required to contribute. Mr. Barnes may even require such protections himself. However, it should be noted, in accordance with Section 54, subsection 2, any limited partner's liability will only be limited with regards to liabilities incurred by the business in the state of Queensland, with a corresponding law exception in subsection 3. It is also relevant that, pursuant Section 60 of the Act, a limited partner may give advice on financial and contractual matters of the business, however, must not take part in the management of the business. Doing so will result in the partner being subject to unlimited liability as per subsection 4. There are some other rights which are unavailable to limited partners at subsection 5, including the right to vote on ordinary business matters and the admission of new partners. This provision may be useful in encouraging the general partners to allow the inclusion of a limited partner. However, may discourage some prospective limited partners from investing their skills. As such, the rights in subsection 5 may be offered to limited partners upon the agreement of management. Given that Mr. Barnes intends to establish a small business, I will not be advising that he organise his business as an incorporated partnership, a private company, or a public company. However, I will inform him that the structure of his business is subject to change upon the agreement of the majority of management. Similarly, if he chooses to be a sole trader, he will be able to reorganize the business himself if he wishes. I feel confident that I am well equipped to take on Mr. Barnes as my client, and I hope I have demonstrated my capability. I will ask questions to determine Mr. Barnes' needs and provide comprehensive advice on his personal circumstances. Please advise me when you've made a decision, as I would like to commence preparation for an interview with Mr. Barnes promptly. Thank you.